We have a huge hearing that's happening right now in South Carolina. We got Alex Murdaugh here. And, this entire thing has been, or it might just be a huge headache. And I can't believe how far we are at right now because he was found convicted of the double murders for his son, Paul, and his wife, Maggie. This was almost a year ago, maybe eight or 9 months ago. And now we are here again with Alex Murdaugh on the fucking scene. Sorry, I shouldn't be cussing the first 20 seconds. I forgot about that. Well, we got Alex Murdaugh here, man. He's here, he's back, and he might get a new trial. We'll see. We've got a status hearing happening right now, and no, it is not with Judge Newman. Judge Newman is actually already retired. We actually have a new judge who's going to be overseeing everything, and there's a lot going on that may have happened behind the scenes in the murder trial. We're trying to figure out if the clerk of court, Becky Hill, may have done some jury tampering. When I read the court docs, honestly, I wasn't really fully convinced, but then we have to hear from other jury members. We got to hear maybe even from Creighton Waters, maybe even from Judge Newman himself. But I wasn't really super convinced. And then when I read the state's response to that, I was like, okay, a lot of this does make sense. But there's a lot going on with Becky Hill, not just the accusation of jury tampering. There is also possibly having her son being investigated because he may have wiretapped the employees at the courthouse's phone. He works for the IT department, and he may have done it in order to keep tabs on whether or not his mom was being investigated and who was talking about her and things like that. And we don't know if it's under the direction of Becky Hill. Maybe he did it out of his own volition, or maybe she did tell him to do it. And then not only that, she came out with a new book during this summer. And that might have been what sparked this entire thing, because people in the jury saw that she wrote about the book and they weren't happy about some things. I think one lady in particular, it was like the egg lady, the one that we kind of all had, a quick little giggle with about. She was about to be dismissed and she's like, well, can I get my eggs? And then Judge Newman's like, you got eggs in there? Like, why you bring eggs with you? But anyways, with that, Becky Hill came out with a book, and it seems like there was at least a jury member who wasn't happy with it. And they, from there, according to Harpootlian and according to Jim Griffin, who are the lawyers for Alex Murdaugh. Oh, my dog is trying to steal my peanut sandwich. Please don't steal my food. Don't steal my food. According to them, it seems that was what sparked the jury to reach out to the Murdaugh attorneys to speak out about other things that were happening behind the scene. Becky Hill. Oh man, so many things going on with her, because behind the scenes also, she was also accused of plagiarism for her book that she wrote. She was in a rush to write this book, and she apparently plagiarized like the first beginning of the book. Okay, we read the beginning, the sample was it on Amazon or something like that? But we read the sample of it, and the first couple pages was completely plagiarized. She stole the preface from a BBC reporter. And her excuse, I guess, was that she had a deadline and she just had to write something quickly and come up with something. But that's not a good excuse. I feel really bad I think her co-author's name is Neil Gordon. He came out with a defense of Becky Hill initially when the jury tampering accusations came out. He came out there, he supported her. He said she was a good person. She was to be trusted. She's honest, all this good stuff. And then a couple months later, he finds out that she plagiarized, and he's like, oh, I don't want to have anything to do with this bitch. We are going to stop selling the books on Amazon, on Kindle. Any of the money that I get, I'm going to be donating it to charity. I don't want to have anything to do with this. So it's a whole mess. And, we're here for it. We have a court hearing that's happening right now, so I hope you guys are doing well. Hi, Weegu. Hi. I believe, how are you doing today? Hi, Joe. My boy Alex getting a round 2. We'll see. I mean, I'm glad they're having this evidentiary hearing, because I do want to hear what's, been happening. We want to find out if he did get a fair trial or not, right? We may not like him. I do believe that he is guilty, beyond a reasonable doubt. And I think a lot of people do too. I know there are some people who weren't super convinced. They were still entertaining the 2-shooter theory. They were not convinced because maybe the lack of gunshot residue and the blood splatter stuff. But I was pretty damn convinced, okay? And the fact that, I don't know, it's kind of can you imagine if, let's say we're done with the defamation trial with Johnny Depp and Amber Heard. We are done with it. We're like, oh, justice has been served. Johnny Depp has won this case. And then all of a sudden, months later, we find out that someone in the courthouse was engaging in some jury tampering. And then Amber Heard might get a trial all over again. That's how crazy it is to me. Almost. Pretty much there. Yeah, we're pretty there. I don't know. This whole thing is, but that's we want to have a fair system, right? If someone's doing something shitty behind the background scenes, we want to investigate it, and from then on, let's find out if this man is going to get a new trial or not. So, let's see what happens. Let's see what happens. Oh gosh. All right, y'all. I hope you guys had a wonderful weekend. And I saw Emily D. Baker. She wrote a YouTube thing about this saying that, Alex Murdaugh's trial starts at 8:30. I'm like, oh God, I know she's probably East Coast time, right? Oh my God, 8:30. Oh, that's too early. There's no way in hell I'm going to wake up at 8:30. Yeah, no way. So we are streaming for the people that haven't woken up yet, or people who are on the West Coast time. Maybe you're Hawaiian time. Maybe you're in a time zone where you're just I'm still working and I can't be watching it live right now. So we're a little bit behind, but it's okay. We'll catch up. We always do. Usually they have a huge break where they break for lunch for an hour plus. So we'll catch up. We'll see. YouTube is just acting shit. What is the shit that it's acting? Let me see. I think my Discord is broken or something. It says you sent me a message, but the last message I saw is the message that I sent you on January 4. Oh, you did? Okay. All right. But hi, y'all. Good morning. Hello. We are the late risers. We have the Alex Murdaugh status hearing, new judge, and we're going to find out. Oh, it's already over. Cool. This is going to be a short day then. It won't be too bad. Essentially, what this hearing is going to determine, or what the judge is going to determine, she's going to determine what sort of evidence will be heard, who's going to be the witnesses. In Alex Murdaugh's recent motion that he filed, it included wanting to have Creighton Waters as a witness because they were accusing of Becky Hill of giving information to the state side and not providing it to the defense side. I think one specifically was about what the public's impression of the witnesses were, and she passed that opinion along to the state side and not the defense. But I don't know if that really matters or not. So I don't know. We'll see. Hi, Perplexity Gold. How are you doing? Look at that little squirrel. So cute. All right, y'all. We are starting it. I got a little bit of breakfast here that I'm going to be eating, and y'all ready for the ride? Are we ready for this? Oh boy, are we ready for this? All right, guys. I think the audio, I'm going to boost up the audio as always. That way y'all can hear. Oh, Joe's on Twitch and YouTube. Hello, what's up? Got Alex Murdaugh. Where are we starting at? Oh, that's new judge right there. New judge.
This matter. December 2020.
All right, here we at. Oh boy. Alec Murdaugh must be so excited. Because just imagine, you're sentenced to life in prison. Life in prison. You ain't got nothing to do. This is going to help him kill the time even more. Whether or not he gets a new trial, or whether or not he just has to show up to all these court hearings and at least have a light at the end of the tunnel that, oh my God, maybe I get a new trial and maybe they won't find me guilty the second time. All right, can I not, what is going on here? Can they not unlock this?
Allow me to use both of his hands, please. We are. Thank you.
Here's his other attorney. What was his name again? David, maybe? Maybe David? Walter White from Breaking Bad. Because he's white. Tis. Maybe because the shaved head.
Hearing procedure in the matter of state against Richard Alexander Murdaugh. Its case numbers 2022 GS15 00592 through 00595. Defendant Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges. His trial began on January the 23rd, 2023. The presiding judge was Clifton Newman. After 6 weeks of trial, on the evening of March the 2nd, 2023, the jury returned a verdict of guilty on all 4 indictments.
My God, that was a year ago.
On which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeals of his convictions and sentences were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, the defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings, on October the 17th, 2023, the Court of Appeals granted appellant Murdaugh's motion to suspend the appeal and to remand this case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023,
Hi, Leela.
on December the 18th, 2023, Chief Justice Donald W. Beatty signed an order appointing or directing that the Honorable Jean Hafer Toll, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press has been allowed to bring in certain cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom.
Fun fact about this judge, she is the first female who served as the first Chief Justice. Where's it from? 2000 to 2015. First female, let's go.
So please now, if you haven't already, check your electronic devices and be sure that they will not sound during the time these proceedings take place. Major topics to be covered today
Everyone's checking.
have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put upon the record as we proceed through these topics that deal with what should be covered. The first topic is an evidentiary hearing necessary at all? The state took the position that the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that on matters affecting the arguments the state makes about the procedural posture of this matter.
Oh, Dave Barber, that's the other lawyer's
name. Next topic
name.
would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof?
Defendant, right?
And what must then be shown to contest what has been shown and proved? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because of what was known before a verdict was rendered, accepted, and the jury polled. And finally, we need to discuss witnesses, juror witnesses. The clerk of the Court of Colleton County is ill, and other witnesses and exhibits.
The defense also wants Becky Hill's daughter to be a witness. I wonder why.
Note that,
why the daughter?
One attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. when I get to the portion of this discussion where we talk about...
Oh, is Eric Bland in there?
And if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided.
So Eric Bland, if you guys remember him, represented some of the Alec Murdaugh's victims. He also represents, I think, 4 of the jurors of this case. And there is like apparently some drama a long time ago between Eric Bland and this judge. She reprimanded him for something, and then like later on it was overturned by the lower courts, something like that. That's just a horrible summary. But he wanted to attend this hearing, and he was like, why did I not get an email about this? Why did you guys tell me about this hearing? And so he obviously wants to attend, right? But they were saying, they're like, oh, you don't really need to attend, but I guess if you want to, come. But yeah, of course he wants to be there.
But I would at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris. With that, Mr. Harper, being you on the moving party, you may proceed.
This is a nice courtroom.
Please, the court, Your Honor, you've raised, I assume you want to go in the order in which you just...
I would.
Okay. You've raised a number of legal issues from whether we've waived, I mean, a number of...
No, Dick, speak into the microphone. We can't hear. No.
Order in which you just took them. Mr. Griffin is going to address those in seriatim based on what you said just a moment ago. As to the witnesses and the jurors, I will be handling that portion of the argument today.
Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. In a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all 3 statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly before the defense put on their case, Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and 2 alternates at least watch his demeanor, which is an indication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, for the state.
Thank you, Your Honor. May it please the Court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural law.
Oh, if you guys only have one ear button, the one on the right side is way louder than the left side. Just FYI. I don't know if you have like earbuds, AirPods, and just letting you know.
And those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations in conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated in that 630, in that affidavit only said that she voted guilty. She had questions but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is an appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing to go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good.
Oh no, Ken. Hi.
With respect to, well, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state takes a position contrary that a Reamer hearing is required. They're arguing that we had sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted. That's all I was saying.
Well, in conversations with Mr. Harpootlian and Mr. Griffin, they were going to actually look into that and look at their paralegal notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here's my position on the matter.
Oh, I like this judge. Okay, let's go.
First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. Now that says nothing about what the burden of proof should be, and I don't intend to say anything thereby, but I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right.
Yes, Your Honor. As we cited in our papers, we believe that the controlling case in this instance, based on the scope of conduct as alleged, and that is conduct of a court official here at the clerk of court.
Wait, where Becky Hill at?
With the jury about the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kittredge says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993, and the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard. Is the question of was the subject matter of the communication harmless and that it could not have affected the verdict. And that's our position on the standard. Your Honor, if
I guess what happens if the communication was like seem as harmless, but the members of the jury were like, oh, well, that didn't affect my decision at all. Like it didn't affect me. You know, I wonder, how do they weigh that?
If Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias. and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. And that was the standard that the Court of Appeals applied to State v. Green. In the State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kitcher says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were, and never became deadlocked, then the judge may ask you to stay locked. I mean, that was the communication by the bailiff in Green, and Justice Kitcher said that did not go to the merits of the case. Justice Kitcher didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision, looking to the Fourth Circuit, because, as Your Honor knows, this case, and I would encourage the Court to look at the Holmes decision out of the Fourth Circuit, which we cited, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kitcher says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense, and it's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. Excuse me, the burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Sorry, Carl. Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant, Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external.
I've never watched a retrial. I don't think I have. I've never seen a retrial before. If there is a retrial, I am for sure watching it because I want to see how it goes down. Like it might be completely different than the first trial. I think there's gonna be a lot of things that are probably not gonna make it in because defense, they made some mistakes and they let in like the roadside shooting, the financial stuff, and I think they're definitely gonna be way careful in the second trial. I want to rewatch the retrial if there is one.
Influence and that sort of thing, and that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the State Supreme Court, it cites Aldrin and Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldrin, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake, in 1992, the court held, don't presume prejudice. And the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case there was a pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than's even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice, again, the burden being on the defendant. In Bryant, this was a capital case, one that argued way back when, and in that instance there was a police investigation, background investigation into death-qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State v. Pittman, another case that I argued before, Your Honor, in that particular case there was a juror who had a conversation with his wife and with the bartender, and ultimately again the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here, and then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot, and I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, is clear, it's in sync, it's uniform, that it's the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order of which the evidence hearing should go.
Thank you, sir. Mr. Griffin, can you reply?
Yes, Your Honor. There is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed Juror O, who had gotten the pamphlet, voir dire every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited in the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a merits communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe the Orange County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand. And we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established, but the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is the touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right.
Hey, question, guys. What do you think about the speed of the video? Is it too fast for you guys to catch on, or should I slow it down? I feel like the speed is good for the judge, maybe even for Murdaugh's attorney, but Creighton, he talks kind of fast. Should I slow it down when Creighton speaks? Maybe I'll do like 1.25 when everyone else speaks, but when Creighton speaks, I'll be like, okay, you get one, sir. Maybe even a 0.75 because he speaks so fast. But, well, for people who watch XQC and streamers like Destiny and stuff like that, yeah, you're used to this shit, right? But a lot of us are not used to it. A lot of them, they're not used to it. The speed is fine. Help speed through the defense. Okay, so I'll speed up for everyone else, but for Creighton, I think it's good. Do you guys agree? Should we slow it down for Creighton, though? Here, we'll listen to Creighton again.
Mr. Waters? I'm not going to go back and forth a million times, but if you want to have a short comment and additional part.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was. Your Honor, Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grobenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly all of those were external influence cases, Your Honor.
All right.
Good?
I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is. when a motion for a new trial on the basis of after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take.
I like that.
All right,
I like
the
that.
next area of inquiry.
So she was saying that prejudice would not be presumed. Instead, it has to be proven. And that's the route that we're going to take. All right, let's go.
Is the procedural.
So I believe the onus is on the defense now to prove that there was prejudice taking place with the actions of Becky Hill. Pretty much all Becky Hill actions, right? I'm trying to think if there's anyone else that could have. It pretty much is all Becky Hill. Yeah, Becky Hill. Becky Hill. She's going to be the center of this.
Argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense is aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's the plan of procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
Okay, later on.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented.
And other potential witnesses. This defense wants Becky Hill's daughter. I don't know what role she has in this. I don't know what job title she holds. I should probably Google her. But Becky Hill's daughter. They want Creighton Waters as well. They want Creighton Waters' paralegal to be a witness as well. And then I remember potentially before they wanted, Judge Newman, the jurors, of course, Becky Hill, of course. But so far, they're just going to argue about the jurors and Becky Hill. And I guess all the other witnesses, that'll be later on.
Should present them and how they should be questioned and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other jurors are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, the question of jurors. The only question is, not the only question, but the first question would be, as Your Honor questions these jurors, would you, in all cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed. Maybe two have not been interviewed by SLED and given statements, recorded statements. The rest have all given recorded statements. And then SLED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. I mean, there's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused, the alternate because she wasn't needed, the egg lady because the judge found that she had had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So
yeah, get the court to do it.
And then we have the court herself. I talked to her lawyer this morning, who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify. And obviously that would be on a question-by-question basis. Maybe, I don't know, I mean, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails that were furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits it would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness because the burden is on us, if Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make a proffer. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant. In your decision decide you didn't consider it or whatever. But a stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury's going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the papers, we don't have any specific knowledge, that she was aware of that, and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. Now, we're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is...
Oh, so the ethics complaint was separate than what's going on right now. Okay, I wasn't really sure what the timeline was for that ethics complaint for the wiretapping, but he's saying that like that's not involved in this case. That's something completely different, not relevant. Okay, thanks for clearing it up.
We furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case and she's going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th. Yet on the morning of February 27th, she tells in the chambers, a hearing we were all present at, that she has seen a Facebook page posting by egg lady's ex-husband alleging that she was talking about the case and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the egg lady's husband. Turned out to be a guy I interviewed in Georgia apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. But the last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, if you finish with the juror, do you want us to submit questions to you? Do you want, I doubt you're going to let us question them. How is that process going to work? And will that be done someplace, will it be done in this courtroom? Will it be done somewhere else? And if the jurors are going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your intelligence. And Mr. Griffin rightly points out, it's not just what they heard, may have heard from the court, but did any of the other jurors, for instance, Egway, he called her, gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch the body language testifies to Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, was it, did it, or did the sitting juror or the alternate in the,
You okay, Harper Lee?
memorandum of interview. Now, the court's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the court when she was interviewed. But in the memorandum of interview, she, that is, the court indicated she had conversations with the forelady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI for us to call the SWET agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the SWET agent. We're not going to, and Your Honor, we're not, you indicated that you're not going to want to know any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact-finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those. We can put those in the record today, or have those available to you, both the MOIs and the videos. Or I mean, we're obviously we're going to do whatever you tell us to do. We're looking for some guidance. So if there's anything we can get you part of that evidentiary hearing concerning those memorandums interviewed by the SWET agents. And the videotapes, whatever you instruct us to do. Thank you for your indulgence.
So I think that's why their motion came so late, because they said that last week they got thousands of emails of communications with Becky Hill, and that's probably why they decided to include Creighton Waters and his paralegal into the witness list as well.
Your Honor, we mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us that this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says...
I love her accent.
Occurring during the course of the jury's deliberations, or to the effect of anything upon that, or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, and what are you saying that imports to this?
Well, I mean, for instance, if we show you, we prove to you that the court said, "Do not be fooled," or watch Murdaugh's testimony, watch the body language, inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if the juror gave the affidavit, would she be asked, did you discuss that during deliberations? Did you do that?
That apparently is very questionable under the terms of 606.
Yes,
and I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they're asked about improper context and they talk about improper context, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the jurors about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing the questioning at this point. And I'm trying to see what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the Court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which would be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment. And we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness, and obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time, but I don't know that there's been such an identification between Ms. Hill and the state that would allow, A, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question-specific, and so, again, it may be something that this court has to rule, as is in any sort of evidentiary presentation, question by question, based on any objection by the party. So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night, and there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense, and if any additional information arises, we will continue to do so. But both.
Hi, Leela. That's what this hearing is for. So, we're going to have an evidentiary hearing in about 2 weeks at the end of this month. This hearing right here is going to determine which witnesses are going to be a part of that, what evidence is going to be let in. And at the evidentiary hearing, from that on, we'll determine whether or not, or the judge will determine whether or not he gets a new trial. From reading the motion so far on the defense side and on the state side as well, I don't think, in my opinion, it didn't seem that it was strong enough to support that Becky Hill did engage in jury tampering. But when we go to the evidentiary hearing, that's where we'll really get to the meat of it. So we'll see.
Last night.
It's crazy.
And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit, and that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time, but I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would, would take the positions that I've outlined here today.
Why are we looking at Alec?
You reply.
Please support, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I noticed to be surprising to Mr. Waters, is motive. As if he'd never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive.
Okay.
Selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed you're going to ask the questions, whether we agree or not. And we do agree with that. The question is going to become, as we go through that process, how, if a juror says X and they said in their interview Y, or if they said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom and have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC, they were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you.
Well, I mean, just because 3 of them went on to a TV show doesn't mean the rest wants to have their face plastered everywhere.
With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. Mm-hmm. And 2, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact.
Oh, the Murdaugh evidentiary hearing is going to take place the same day that Sarah Boone's trial is going to take place, January 29th. I mean, unless hers gets pushed. It might get pushed, right? She's got a new attorney. It might get pushed.
Contacted any had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allocation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proper, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case.
Oh man, the defense is not happy. It's not sounding good.
So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I rule that they're not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked.
Yeah, Sarah Boone's pretrial hearing is today. I wonder what time.
Some of the suggestions that are made and the filings you made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of
Sorry, she won't allow?
the subpoenaing and examination of attorneys in this case, of the acceptable in evidence. I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case,
Ooh.
of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it.
Wow.
It's about 11:15, not close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things when I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered.
Eric Bland.
So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I've just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor. Thank you, Your Honor.
I mean, at least the evidentiary hearing is going to take place, but I will say those are blows to the defense because the defense, they want to do a very broad investigation into everything, okay? They want to investigate the thousands of pages of emails. The judge was like, nah, we're not going to have that. They want to have Judge Newman as one of the witnesses. Judge is like, nope, we ain't having that. They want to have Creighton Waters, his paralegal team, as a witness team as well. She's like, nope, we're not having any of those people. We are going to do a very important investigation. We are going to solely focus on the jurors, which I always have a hard time pronouncing, the jurors and Becky Hill. And it's not going to be like we're going to ask her a bunch of questions trying to get some investigatory stuff, but we're just going to ask very important questions like, did you engage in, like, let's say, for example, the jury, right? It will be, what was it? She's going to ask the jury about the verdict, not the deliberation part, but the verdict, whether or not their verdict was influenced by what Becky Hill said to them. And then also, was there improper contact that was made? It's going to be very, very focused. She's like, we're not going to be exploring all the other things that y'all want to focus on, okay? We're going to be just doing this, and the only witnesses are going to be these people. Hi, Benjamin Lee. How are you doing today? How's it going? You think Alec is such a weirdo? Oh my God, someone in chat. Was it Nicole? Nicole said, Sarah Buffoon. That's pretty good. That's a pretty good one. Sarah Buffoon, or Sarah Boone, sorry. Sarah Boone. Sarah Boone is supposed to have her pretrial hearing today. I'm going to keep refreshing the YouTube to see if it pops up, but we'll definitely watch that as well. Her trial is slated to happen the same day that Murdaugh's evidentiary hearing is going to happen. So we got two trials going on at the same time. I'm like, which one should we do? Which one should we watch? Am I a lawyer? Nah, I'm just a nosy person who just likes watching this stuff. But we got a little break going on. Oh my goodness. Yeah, it's not looking good for the defense. If they are solely just going to focus on the jury and Becky Hill and keep their scope very limited, I honestly don't think the defense has enough to prove that there was jury tampering. But who knows? Maybe Becky Hill will say something on the stand, or maybe the jurors will say something on the stand that wasn't part of their signed affidavits. But so far, I don't think Alec Murdaugh is going to be getting a new trial. But like I said, there could be a lot of things that gets uncovered during the evidentiary hearing. All right, guys, they're going to go for a little break. Should we stretch really quick? Good for her. The judge isn't getting lost in the minutia manure the defense tried to throw at her. Oh. Stretch, y'all. Get a good stretch in. Oh, man. I hate it when things are going to happen at the same time. We got Boone at the same time and the Murdaugh one at the same time. Do y'all know if any of Alec Murdaugh's family members are in the back? Did you guys see Buster? Any of his brothers?
And not on either that alternate or any other alternate. With respect to...
Oh, and then also, it seems like what the judge is also saying, they're not going to be exploring that Facebook post with the egg lady. They're not going to be exploring another Facebook post with the ex-husband. The juror said that the wife will vote guilty just because she's simply a man-hater. I don't think any of that's going to be explored at all. I know Harpootlian and Griffin, they definitely want that to be, in part of the line of questioning, but I don't think it'll get there, at least not right now.
That nature.
No, I hate when people defend themselves.
How the jurors will be questioned.
When they try to represent themselves, it is just a shit show, okay? It slows everything down because they don't know what they're doing. They always have to ask a million of questions. The state always has to clarify. The judge always has to clarify. Like, I just rather have a very experienced, seasoned lawyer or, maybe a new attorney who just graduated from law school. Who cares, right? Be the lawyer who's going to represent the client. When the client starts representing themselves, I'm like, oh my God, things are just slowing down for no reason. Like, please get off, get someone, just hire someone. Have a public defender.
Everything can be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses.
Fair.
There's some need to further obscure the way they are presented. We can talk about that, but they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys both on jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's request, and I'm very confident they will be in this matter as well.
Hey!
With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case, and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony, I do not use communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case, and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony...
So that means no egg lady and no other Facebook lady whose husband was like, she hates men. Okay.
I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the party should subpoena these witnesses, and when it comes comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by support personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted
Hi. Hey, Rod. Good morning. How are you doing today? Good morning, good afternoon, or good evening. Hello. You're welcome, Katie. Oh, and I also want to mention, one of the most important things that the judge has determined so far is that jury tampering will not be presumed. It will have to be proven. And that was a blow for the defense for sure.
allegations made is the clerk of court. The jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing.
Yeah, that's in 2 weeks. So 29, 30, 31, Monday, Tuesday, Wednesday. So they think it's going to take roughly about 3 days. Oh my God, this is the same time as the Sarah Boone trial. Why?
This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure a court TV monitor that's available for them to monitor the proceedings if there's not enough room. Based on the attendance today, it might be plenty of room. We'll see. We'll have this as, I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention.
Oh, what's the burden of proof here? I'm not quite sure. Yeah, I'm not too sure. I'm trying to think. Hold on. Have I heard this before? What is the burden of proof here? Yeah, because preponderance of evidence is like more than 50%, right? Like 51 and up. Beyond a reasonable doubt, that's like when you're going to trial. I'm not quite sure. I'll look it up.
think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what.
I mean, I guess it would just have to be the judge has to determine if there was improper contact and whether or not this improper contact resulted in the jury to actually be affected by it. So I think that's just really what they have to prove with at least one of the members of the jury.
Furthermore, for the parties, as to what furthermore needs to be discussed, and then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill any other issues that still need to be developed. Mr. Hopkins.
Please, Court, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors?
I think that's what she said. I think she said that she wasn't going to have the alternates be questioned. They're only going to focus on the members of the jury who actually were involved in like the deliberation into the process. I think that's what she said like a couple minutes ago.
They were all told this at the same time.
I'm not sure I understand your question, but I'm just telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Oh, okay.
At the present time, I see no necessity for them to be called to say what the clerk said because we're talking about what the clerk said to the remaining jurors.
So
those
that's
who
a no.
actually sat on the case. The corroboration is something I don't think I need it this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
Yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
I love this judge so far. She is very clear, very cut, straight to the point.
Well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given. I mean, we can get more detailed affidavits, you know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that.
I forgot that Harpootlian, during the Murdaugh trial, he did have a lot of outbursts. I'm like, yo, Harpootlian, like we're in court right now. Like, I know you've been like a lawyer for a very long time. You're probably prominent. You're probably prestigious, but I forgot that he had a lot of outbursts when he was in Judge Newman's court. I don't think Judge Toll, I don't think she's going to be taking his shit. Moondog, thank you so much for the resub for 20 months. How are you doing today? Moondog from Twitch, thank you. I appreciate it. Yeah, I think in this case, it's just that if the judge sees there was improper contact and she believes that affected the juror or the juror's decision, then he gets a new trial, I guess. Oh, man. All right, let's see what happens here.
Two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people when I've got to direct people to whom it said that I will question.
Well, Your Honor, we did submit an affidavit, but I had no problem going back.
You submitted one alternate affidavit
right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So,
And that doesn't prompt me to change what I just said to you.
all right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
They got paid $100.
Just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them that they, A, will not say anything, and B, did not say anything, then that may clear the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken to them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever.
Very good.
I mean, I guess I get what the judge is saying. She wants to be very specific about this, right? She wants to focus solely on the jurors who deliberated and then Becky Hill, of course, because the allegations are made against her. From then on, maybe she'll consider expanding it out a little bit to, the jurors that were dismissed, right? The alternates. So I get what the judge is trying to say, but I know why Harpootlian wants everyone, because, Harpootlian, he wants as much as he can into this. He wants, he wants the egg lady to be in there, the other alternate juror. He wants like the legal team to be a part of this, Judge Newman. So, we know why Harpootlian wants all of these other people in as like witnesses, right? But the judge just wants to be very, very specific. But then she says from then on, maybe, it's possible I might change my mind that maybe we'll have the alternates question as well. Yeah, this is she's a female judge. She apparently, hold on, I looked this up earlier. Did I already exit it out? I might have exited out. She was the first female judge to serve as like a chief justice in South Carolina. Fun fact.
All right, anything further before I go to the lawyers for the jurors?
You're only one other point, and that is you asked us to give you the exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SLED.
It'll make it a lot simpler if it's a small number and a discrete number submitting them to me. Again, I told you I would evaluate that when I did.
Of course, I don't think you can evaluate them until she testifies. You don't
I think you're going to have to trust that I am going to do some evaluating before she testifies.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates are to be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay. That's fine, or scriptors of some sort from you as to what you intend to do. I'm not going to dictate how you do it, but I'm going to have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit something.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree. But, again, I will tell you how I'm going to accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say we're going to hopefully be able to get affidavits from these folks.
Yes, sir.
Much more descriptive than the original affidavits.
All right.
Thank you.
All right.
Your Honor, may I consult with counsel very briefly?
Sir.
Oh, what are they talking about? I want to hear. I'm nosy. I don't know if he looks happy. Harpoon doesn't look happy. Oh. They blocked it out so we can't listen. Yeah, I don't see any of the Murdaughs behind there. I don't see Buster.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those. I
Sure, I'd be glad to review any of that.
discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send.
But it's good, though. It's good that Harpootlian is fighting, and it's good that Harpootlian's asking these questions because, you know, you want to have an attorney that's going to interject for you as much as he can, right? It's good. Harpootlian's doing work for Mr. Murdaugh over there.
Something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes sense.
That might be the better way to do it.
Yes,
Because, again, I can very easily examine a flash drive, even though it takes a long time. Typically, you're kind enough to provide an index at the front of the flash drive as to where the various
That's the judge over there, y'all.
materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz, the clerk, as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCullough, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
But Your Honor, Ronnie Richter on Murdaugh is part of
Went
it.
a little fast for me.
Ronnie Richter.
Oh, Ronnie Richter.
Right. Any others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come
Yeah, I don't think I see any Murdaughs back there. Maybe Buster? No, I don't think so. No Murdaughs back there.
forward.
Yeah, I don't see them. Oh, wait, is that Becky Hill? No, no, I don't think so. I don't know. Is that her? No, I don't think so.
Ronnie and I represent
Brooke, is that you? Brooklyn? No, I don't think that's her either.
4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege, and you may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity.
So apparently he got in trouble a long time ago in the current judge's courtroom. So there's tiny little bit of drama between the two of them. That was a very long time ago.
And that they're not harassed.
Oh, actually, hold on a second. I heard that he was talking shit about the judge on a podcast, though. I read this last night. Was it on Court TV or maybe it was on Court TV? He was talking shit about the judge. He was saying that like the judge will piss on every corner of the courtroom because she's very territorial or something. I'm like, why would you talk shit about the judge in a podcast? Was this Court TV or let me find it. Hold on.
A good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, the big batch of emails that Mr. Harpootlian referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You've indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this.
Oh, okay. Hold on. Let me read this to you guys really quick because, you know, I love giving you guys the tea. The tea. Oh, God. Okay. Here's what we got here from Law and Crime article. Murdaugh's lawyer have asked Judge Toll, to bar attorney Eric Bland from participating in the hearing. Bland, his law partner, Ronnie Richter, so those are the two guys that are standing up there right now, represent 4 jurors in the Murdaugh's trial. Richter told Law and Crime last month that he expects the jurors he represents to tell a different story than those who have reported hearing Becky Hill making comments about Murdaugh during the trial. However, Bland seemed miffed on his podcast that he was not invited to participate in the status conference, which is this one right here. In court documents, Murdaugh's lawyers detailed comments Bland made about Toll in an episode of a podcast, Cup of Justice, on December 26th. Murdaugh's attorneys told on him. Here's a quote. She has friends sometimes to reward and enemies to punish, or she has friends to punish and enemies to reward, Bland said on a podcast. The quote was mentioned in one of Murdaugh's briefs. Bland said he didn't like it when he heard Toll had been appointed to handle Murdaugh's motion for a new trial. He described her as smart and prepped, but also as a strong presence. She pees on every corner in the courtroom. It's hers. I mean, I guess not really talking shit, but that's an image I do not want in my head, okay? Bland said on the podcast. The comment mirrored one made by Murdaugh attorney Dick Harpoon to a website about his strategies for a trial in which he discussed owning the courtroom and invading the opposing party's space to create anxiety. Bland conceded he might have a bias due to a 2008 decision in which Judge Toll, found Bland and Richter violated a court order related to a settlement agreement. The decision reversed a lower court decision. Bland credited... the decision reversed a lower court decision. I thought the decision was reversed by a lower court decision. Oh my gosh, I read that wrong initially. Sorry, I reported it wrong initially. Bland credited Toll with being fully prepared and lively during the proceedings. I mean, I guess he wasn't really talking shit about her, but that's an image that I did not want. Okay, the judge was peeing on every corner of the courtroom. I don't know. I just think of just like a little doggy raising its leg and just peeing everywhere. Oh, you're having back surgery? Oh God, you need to have 3 separate ones. What? Was it like a car accident? Did something happen, or is it something like scoliosis? You just have to fix it. Hello, Big Von. How are you doing today? What an odd thing to say about a judge. I mean, she does have a strong presence. I do like the judge, though. She seems very, I hope that when I'm as old as her, I'm as intellectually there. Okay. I know I'm not right now, but maybe when I'm old and stuff, maybe my mind is going to be just as bright as hers. Now I'm waiting for the judge to casually get him to go piss in the corner. Oh boy. Okay. So yeah. A little bit of drama behind the scenes.
The significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason. That I don't know what the jury's going to say, I don't know what you're going to rule. But let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion of the closed courtroom, that the press would be present, that their likeness, both voice and face, be modeled, just as an additional safeguard. But I certainly appreciate.
Corey, do you think you're a dub? No, I'm just not sharp like some people are. You know how some people this is the thing that I say a lot about white people. Okay, white people are so good with analogies. They're so good with their words. They're so good with sentence structure. I struggle with that a lot. It is very hard for me. And I think one of the things that really makes it tough for me is because I like to talk so fast. I need to slow down. I need to talk slower. But at the same time, I was also an ESOL student for up to 4th or 5th grade. So English has always been a struggle for me. I wish I was an English major, and I wish I wrote more when I was in university, because I feel like that could have helped me a lot right now. But I don't know, that judge right there, she seems very sharp. And I hope that when I'm that old, I hope I am just as sharp. Okay. I don't want to be mentally deteriorating. I need to slow down. Stuttering is too much for me. Yeah, I stutter a lot too. If you guys ever hear my brother talk, my brother stutters so much, dude. Oh my god. I can't talk to him too long because I'm the type of person where if someone's like idiosyncrasies are very prominent, it'll rub off on me. So if I talk to him a lot, I'll start stuttering a lot too. I have an aunt that when she talks, she blinks like a shit ton amount of times, okay? If I talk to her a lot, I'll start blinking a lot of times too. So I don't know. Ugh. Anyways, it's hard, okay? English is hard. Talking is hard. Getting your words out is hard. Because like when I have thoughts in my thoughts in my mind are way more, they sound way more constructively, like they sound better, okay? But then when I speak them out through my mouth, it's like there's a huge disconnect between what's coming out of my mouth and like my brain. Yeah. And I used to do drugs a lot too when I was in like high school. So that probably not very good. Okay, don't be doing drugs when you're young.
With the safeguards you have put in place, I respect your ruling. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see jurors who've given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to.
Oh, sorry, I'm going to interrupt you really quick. Also, if you ever record yourself talk, and especially if you ever edit yourself, you notice that like for me, like when I speak normally, right? Like I don't think it sounds as bad if you're just listening to it. But when you're editing it, you notice it so much, like especially the filler words, the the like, the so, the all right, like a lot of those, because I have to edit those out, they show up even more to me. Because I think like I probably talk like how a lot of people talk, right? We use a lot of we use a lot of likes, but it's when you have to edit it. It's when you have to listen to yourself. Like try recording yourself for a second, right? Record yourself for a second, and then you'll notice like how many filler words that you probably use. Yeah, I don't know. I wish I could talk like a lot of these, like Credit and Waters, right? Credit doesn't have filler words. A lot of like attorneys, a lot of judges, like the way they speak is like very like great elocution. I wish I could be like that. Oh, I was scared for a bit. A few of my female friends who really didn't like math, thought they were dumb for a long time. They're not. One of them is a highly intelligent. Yeah, I mean, like I think people have like intelligence in like different arenas, right? There's also like emotional intelligence as well. There's also like book smarts. Some people are really good at math. Some people are not. Some people are really good at English. So I think people are like smarts in like different areas. So yeah, I mean, there are some people that you meet that you're just like, okay, they're just kind of straight up. They just seem pretty fucking dumb. But I like to think that people have different areas of strength, and they're just not like all just completely just like, blanket dumb.
Even if it included members of the press, but not the general public. I don't think that is in keeping with the public nature of trials in this state and public.
All right, let me go back a little bit. Oh, thanks, Studio. You're getting English degree? Yeah, I wish if I were to go back in university, I would study English. I think that would have been really fun. English major. And
I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press, but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protective as you think it needs to be.
Trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena. so that they don't have to do
Well,
so.
that's great, and of course, you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers, or you want me to wait?
No, sir. You can.
Later.
I don't need that at this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir. Mr. McCullough?
Would you like me here or later?
Go to the podium if you would, please.
Wait, Mr. McCullough, where? We saw him. Where do we see him again? He looks so familiar. Why is he so familiar? I don't think, does he represent like one of the jurors? But I could have sworn I saw him elsewhere though, not representing the jurors. Who is he? I swear to God, we've seen this guy before.
I believe that some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course,
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630. One is
But like, I feel like we've seen him before. Way before the jury tampering allegations. Mr. McCullough. He's one of Boone's attorneys. He's not, though. Are you talking about the sixth attorney? The sixth attorney was like, I don't know, I think he was like struggling, okay? This guy's, I think the other attorney that Sarah Boone had, he had like, well, he had scoliosis or something. He was like struggling.
with a deliberating juror, I suppose we call her, and the other was the removed juror.
Right. And with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I rule that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootman is going to submit additional information. As regards your client, I'd ask you to submit that information to you as well.
Oh, I think okay, now I think I remember him. Yeah, I think he's representing the jurors that that spoke with Harpootlian and Griffin. I think these are the jurors who had the affidavit that was included in the defense's motion. Yeah, okay. Yeah, so he's representing the alternate jurors and like I think like one that was like an actual juror.
And then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not alternate. She was an actual seated juror.
The sitting juror.
Who was removed at the end of the trial.
Oh.
Prior to deliberation. Whoops.
I need Mr. McCullough to speak up, please.
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and is part of your record. And my letter of November 10th responding to that filing is also part of your record. But the state said that jury duty is this cornerstone civic duty, needless exposure to the jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willing.
Anyways, Corey, I improve my writing a lot by arguing with strangers in the comment sections of the internet. Where is this on? Like Reddit? Twitter? I don't know. That would drive me nuts. I rather argue with people like in this type of thing where people are typing it to me and I can just like say it because I hate writing things. Oh my God, writing is so hard. Writing is hard. But yeah, maybe that's how I could improve my writing, just by arguing with people on the internet. I was accused of being an AI. 9gag mostly. What are you guys arguing about? What is on 9gag? Isn't 9gag just like memes? I haven't been on 9gag in so long. Maybe like back in the day when there were memes and stuff like that. Also, does anyone know if Sarah Boone's hearing happened today? Was it streamed? Because I'm trying to find it. I can't find it.
The state said that jury duty is this cornerstone civic duty, needless exposure to the jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, the attorneys.
Mr. Cole, let me stop you there. I am not aware
I am not here for this bullshit. Okay, let's move on.
of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is either admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. A negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I'd like Mr. Richter and Mr. Bland appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I would make arrangements for juror witnesses to report to
Leela says Whitney Paltrow's
the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery and a full gallery of press by allowing its recording through, I understand Court TV will be the pool camera. That is to say that I have actually in my history participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying. I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
Thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent rulings.
Thank you.
Thank you.
Your Honor, do you expect
Thank you.
all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And
then Becky Hill?
Will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they need would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off of work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
Mr. Lewis. Oh, he represents Becky Hill, I think. Dun dun.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need him, and happy to accept service to alleviate one issue for this court. unless you need to move on.
Okay, I love your energy.
All right, thank you for that, and before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you, that wouldn't be fair at all, but I'm going to ask them if there's anything else I need to inquire of before I let you go. Because I understand the subpoena, and we would have a formal subpoena of Ms. Hill would be placed in your hands as her attorney, and you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I'd have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
Evaluate that.
Nope.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday, or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here as court begins.
All right. Thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
No. Desert Biker says, or Desert, right? I always get Desert and Desert mixed up. Desert. Corgi, I missed the beginning. This is a new person thing. Alec Hill. No. So he had his murder trial. He was convicted, found guilty for the murders. And they are trying to investigate whether or not the clerk of the court talked to the jurors, may have said some things that they shouldn't have, and influence their decision into getting a guilty verdict. Okay. That's where we're at right now. We trying to figure out if Miss Becky Hill, the clerk of court, was telling the jurors things that she shouldn't have, and maybe it influenced them. Maybe that's why there's a guilty verdict. I'm not convinced of it from reading the motions on both sides. I haven't read the updated motion on the defense side, the one that they filed like a couple days ago. But from what I read so far, I wasn't really convinced, but we'll see. We'll see what happens. We'll see what the jurors say, because I read the jurors like affidavits. I think there are like 2 jurors that we haven't read their affidavits yet. I don't think they're available. I don't think they haven't talked to anyone yet, but we'll see. If we are only going to focus like what the judge says, right? If we're only going to focus on the jurors and Becky Hill, and whether or not there was improper communication and whether it influenced their decision, if we're only going to focus on that scope and not do like exploratory questioning of, you know, the other alternate jurors and Becky Hill about other things that may and may not have happened, if we don't do any of that, then I don't think that they have enough to have Murdaugh get a new trial. But then again, like, I wasn't really sure what was going to come out of the evidentiary hearing, because I didn't know what kind of questions they were going to ask or be allowed to ask. I don't know if there were going to be other things that they were going to uncover about Becky Hill or the jurors. But so far from reading the affidavits, it doesn't really seem like it was much. But yeah, I don't know. Let's see what happens with Becky Hill. Let's see, maybe, you know, because she's an elected official apparently. I wonder if she's going to continue to be the clerk of the court, you know? Because, like, let's say she did say some things that she wasn't supposed to say, but then the jurors were like, oh, well, it didn't affect my decision, like whether or not I thought Alec Murdaugh was guilty, right? Let's say she did say some stuff. I don't know, what did they go from there? But that's up to the judge, and then she'll explain it to us at the very end when she makes her decision. But then it's also like, well, what happened to Becky Hill? You know, let's say the judge is like, okay, you know what? Alec Murdaugh doesn't get a new trial. Becky Hill did say some things that she wasn't supposed to, but it did influence the jurors' decision. So no new trial for Alec Murdaugh. But what would happen to Becky Hill at that point? That's what I want to know. There's a lot of things I want to know. There's a lot going on with Becky Hill.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. So I want to be sure that we all understand exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first off, for the defendant.
Please, Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill, because we don't know what she's going to say. So it's difficult for us. I mean, we at I mean, once she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her.
So the reason why Harpootlian keeps saying over and over again that he doesn't know what Becky Hill's going to say, like, yes, she did have a signed affidavit denying all of the allegations, but I think she asserted her Fifth Amendment right to not be questioned by the Murdaugh attorneys. And they don't know, I don't think it's been decided yet whether or not she can just keep saying that, like, oh, you know, I'm not going to be questioned. But I think the judge did say that she's going to be part of the proceedings and she will be a witness. So that must mean that she can't just go up there and be like, oh, you know, I waive my, you know, Fifth Amendment right to not say anything, right? My right to remain silent. I don't know. That part I'm a little bit confused about. But the reason why Harpootlian is saying that, like, oh, I don't know who we're going to call to impeach Hill. We don't know what she's going to say is because they haven't had a chance to, like, question her yet. They just have the affidavit of her denying all the shit.
Assistance with one of the people helping her. You know, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until fun.
Yeah, because I think they already talked about this. This judge, she is snippy. Love it.
I asked for it again, Mr. Harpootlian. I've told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
But there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, you know, the questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit. That question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to gain this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by a general topic, pursued with witnesses.
Yes, sure.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me.
In advance as to what I am going to do about that, and what is going to be, at least by a general topic, pursued with witnesses.
Yes, sure.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to jury issues. And while he is no longer a lawyer, he was a lawyer at one point, and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdaugh has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be a...
Oh man, imagine if the lawyers had to sit around with Alex Murdaugh for hours and hours as he reviews the papers. Oh no. Not gonna happen. Harpooning Jim Griffin, they're like, we got better things to do. I wonder if they have other clients that they're representing. Was it a Harpootlian only representing Murdaugh as like a favor or something? And he doesn't normally participate in criminal trial proceedings?
Risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is, not my making or yours.
Yeah, I remember donating hair, 8 inches and not bleach. Yeah, I remember because like when you have hair that's like needs to be donated, you got to remember like all this right here, it ain't gonna count because the length is not going to be the same, right? It has to be like starting from here and then like 8 inches down, right? Because I remember a lot of my friends who donated their hair, they grew out their hair pretty freaking long. And also like after they donated it, like I think their haircuts were like all like bobs or something like that. But yeah, I remember I tried to donate my hair. My hair was so damaged. Like, you're not allowed to donate hair that's bleached. I'm like, oh, okay, sorry, I didn't know that. They don't want my crusty, dry ass hair. They want some healthy hair.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. Well, I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review them.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client to effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Hi, Shelley.
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor, ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters of the corporate rule. The only way, though, that I could see them potentially testifying is in the event that there is an accepted witness by Your Honor that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. This is an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not imposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Get on up. Up and stretch. Harpoolian spoke a lot. Jim Griffin spoke in the beginning. Ugh.
I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in perfect form, that folks would like to produce their transcripts. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you, and you may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
It's loud. I think they're supposed to mute this, aren't they? Hi, Turbo. Oh man. Hi, Shelly. Thanks for joining us. Hello. What's the court case about? The murders of the son and the wife? Or, well, it is related to that, sort of. His case is over. He was found guilty. This was about a year ago. However, there were allegations that surfaced towards the end of summer about whether or not there was a staff member at the courthouse who may have said things to the jury that they shouldn't have. And what we are all determining right now, and why there's a status hearing, we're trying to figure out if this man is going to get a new trial or not, which will be crazy. It will be wild. It'll be a shit show. We're trying to figure out if the clerk of court said shit to the jury that may have influenced their decision of coming with a guilty verdict. That is where we're at. And whether or not he's going to get a new trial. But like, see, this is so wild to me because can you imagine if after the Depp v. Heard stuff was over, we're like, Johnny finally got his justice after what? 6, 10, 8 years? He finally got justice. And then a couple months later, allegations came out that, wait a second, hold on. Were the jury influenced? Maybe they were. Maybe there needs to be a new trial for Depp v. Heard. Like, that would be so bonkers. That's where I'm at right now with this one, because I for sure do believe that Alec Murdaugh is guilty. Like, guilty as heck. And for him to have a new trial? But, I mean, if they are able to prove that the courthouse staff did influence the jury in some way in making their decision, then, yeah, he deserves a new trial then. But, god damn, it'll be wild. It'll be crazy. Forgot about Becky Hill. The financial stuff, I think... The financial stuff... They already got the sentencing for the state financial stuff. Remember? Yeah, they did the sentencing for that. Because he decided to have a plea deal with the state. Do I think he would testify again if he gets a new trial? Maybe. Yeah, I think so. I think at this point, though, if he does testify again, there will be an explanation as to why his voice was on the Snapchat video, right? Remember, like, as, like, the trial was happening initially, they were saying that, like, Murdaugh was saying that, oh, I wasn't at the kennels. I wasn't there. And then boom, came the Snapchat video with Murdaugh's voice in the background. And then he had to pivot so hard. He had to testify. He had to explain that. And his lie was, well, I have a distrust for SLED. And because of that, I couldn't be honest with them. It's like, you lying. You have a distrust for SLED. Yeah, the fuck right, man. You thought they were on your side the entire fucking time, okay? This guy over here, he lied. Judge Ascarati was in control of our courtroom. Judge Ascarati was amazing. But, I mean, if there is going to be a new trial, I am definitely going to watch it. Let's pivot on over to Sarah Boone. Ding, ding. Sorry, I'm like obsessed with a Law & Order sound right now. Sarah Boone, I mean, y'all were saying that she's going to have her trial at the end of this month. And I was like, I don't know if she's going to have her trial or not, because her 7th attorney just hopped on the case like a couple months ago. And lo and behold, I looked up her files. They put in a motion for continuance. Okay, I don't think they're ready, which makes sense, because to prepare for a murder trial in like a couple of months, and remember, he is a public defender. He's a public defender, so he probably has like a lot of cases that he's juggling. Also, if I was Sarah Boone, I might dismiss this attorney too, man. He's got an AOL email. Are you serious? Winston932 at AOL.com. If you've got AOL, if you have Yahoo, if you have MSN, like, nah, you're going to get hacked, okay? Get a Gmail account or something else or something more professional. But here's Sarah Boone right here. We have a motion to continue. Bum, 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 bum. Because her trial's supposed to happen. I mean, right now, there's supposed to be a status hearing, but I keep refreshing YouTube. I don't see a live stream of the status hearing, so I don't know what's going on with that. Maybe we'll hear it soon. But motion, you have a Yahoo account? Oh my God. So does my sister. I keep telling her, get out of Yahoo. You're just going to get hacked, okay? You're going to get hacked. Anti-AOL? Yes, okay? No, AOL, Yahoo, MSN? No. Motion to continue, waiver of presence. Come now, the accused, Sarah Boone, by and through the undersigned attorney, pursuant to Florida Rule of Criminal Procedure 3.190F, moves his court to enter order granting continuance and waiver of presence in the above style cause. As grounds for support of this motion, the accused states, number one, that the trial in this cause is set to be heard in the trial period starting January 29, 2024. The pretrial conference is scheduled for January 16th, 2024, today. Number two, the additional time is needed to prepare for the case in trial. Counsel was still reviewing extensive discovery in this case and also seeking appointment of experts. This court has approved cause for a private investigator. What do they need a PI for? The task is to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. I'm telling y'all, I don't think it's going to happen at the same time. Number three, speedy trial has been waived. Yeah, this happened back in like 2020. She's been sitting in jail for like 4 years now. The state attorney has been notified that counsel will be filing this motion and has no objection. I'm telling you guys. Also, this man messing up his emails, okay? You guys ever have like a template, but then you forget to change the dates and stuff like that? Listen, look at this. Look at this template right here. I hereby certify that a true and correct copy of the foregoing has filed in the Florida e-filing portal and has served the parties to this case on the 17th day of September 2021. 17th day of September 2021. This doc is like 3 years old. Are we not updating the dates on here? Winston, we need you to be sharp. Anyways, that's just me being nitpicky. So I don't know if Sarah Boone's trial is going to happen. I haven't seen anything, whether or not the judge has granted this, whether or not he's denied this. And then I've been refreshing YouTube to see if the trial, or sorry, the status hearing is being streamed right now. It's supposed to be streaming like right now, but I don't know. That would be good for me, because I would like it if 2 trials weren't happening at the same time. Well, not 2 trials, but 2 like court stuff weren't happening at the same time. I mean, I do want the Sarah Boone stuff to happen, but you know, if we're gonna have to juggle between Alex Murdaugh evidentiary hearing of 3 days and the Sarah Boone murder trial, like that'd be kind of annoying. But yeah, I don't know. We'll be maybe not too bad. Maybe January. Actually, no. It depends on when jury selection takes place. Maybe jury selection will take place next week. The Sarah Boone trial is weird because she filmed everything they need. Yeah, she's idiot. I don't know. What happens if it never goes to trial? Will she just say, no, it has to go to trial. It has to go to trial. If it never goes to trial and she's sitting there forever, at some point they might just release her. You don't want her being released to the public, okay? How long until the current lawyer has also quits? I mean, it seems like they're getting along. It's like, we don't know shit. Okay, we don't know. We have no idea. Are we sure Sarah Boone was happy to waive her appearance at the hearing? Did Winston double check on that one? Yeah. I think it just means that, like, oh, let's just not show up for the pretrial status conference. So both her and her attorney. But if Winston was going by himself, then I'm sure she would be pissed. All right, y'all. Do we need a recap of the Murdaugh stuff? Are we good? How do we feel about the Murdaugh stuff? How do we feel about Becky Hill? Thoughts? Questions? Let me get this picture out of here. Some trials are just too creepy. Sarah is like one of them. I hope Sarah goes. She's for sure gonna go up there and testify. That is what I'm looking forward to. I am looking forward for her to go up there. She gonna testify. And you know, we saw her interrogation. We saw her on the police body cam when they first got to the scene. Like, she sure is something. Okay, she sure is something. Oh my gosh, have you guys watched this yet? Should we watch it today? Have you guys watched? Anyone here watch May December? It's a Netflix movie. Natalie Portman's in it, and Julianne Moore is in it as well. Dude, the story is wild. She's off her rocker. Let me show you guys another person who's completely also off their rocker as well. I watched this interview of this batshit crazy, insane woman. Okay, she seems like a piece of shit. She seems like a piece of shit. But has anyone here seen May December? I just wonder if you guys know what the background story is. Rihanna says, I think the Murdaugh team is desperate. Becky Hill didn't do anything. How about instead of life in prison, there's a life in suitcase, call it a day? Well, we're not allowed to do tit for tat anymore, you know? That's a thing of the past. No tit for tat. We want to have a normal functioning society. Corgi, what? What do you want? Yes. If you were the judge, you would have to call me Your Honor. You know, some people don't even say Your Honor. They just say judge. Like, depending on what district you are, some people just say judge. Hey, judge. Yep, the story about the teacher grooming her student. And it doesn't end there. It doesn't end there. This was back, like, apparently in the early 90s. This woman, 36-year-old woman, slept with her 12-year-old student. And mind you, she had kids around that age. Okay, I think her son was either the same grade or the grade younger. She had kids around that same age. And this woman she is crazy. They did an interview a couple years ago. Oh, wait, no, I'm totally jumping around. Okay, so 35-year-old teacher sleeps with a 12-year-old student. She's got kids around that age. She goes to trial, and during trial, she was pregnant. Oh my God, she was pregnant. And the judge lets her off easy, puts her on probation. So she's out on probation. And what does she do within the first like couple weeks? She went back and she was caught making out with that same 12-year-old student at a car, and the police caught her and dragged her butt back to jail. And she was to serve 7 years in jail. But during that time, when they were also discussing that, she was also pregnant with a second child by the same 12-year-old boy. Oh my goodness. And so, of course, by the time she got out of jail, he was already 18 years old. You know, imagine this like 12-year-old, 13-year-old raising 2 children all by himself. I think his mom helped, but he was part of a broken family. Like, parents were divorced and things like that. But, oh my God. Horrible. So by the time she gets out of jail, she's like, oh, you're 18 now. There's no law stopping me from communicating with you. So, of course, they get married, and they've been together for a very long time. Well, she's dead now. She died like a couple years ago of like breast cancer or something. But oh my goodness. Was it last year, right? Oh my goodness. Like, she was the character itself was already super cringe in Netflix, but I didn't realize how even more cringe the actual person was in real life. There's this interview that I watch. It's so bad. It's so bad. Let me go to my YouTube channel. Did y'all watch the interview? She essentially, they did an interview, and you know the interviewer is going pretty hard at the woman, and she kept saying to like, oh well, I was being seduced, and the interviewer is like, by a 12-year-old, really, by a 12-year-old, and she's like, I was being seduced. Like, who had the power? He had the power. Like, I don't know, she's like so insane. Fuck this lady. I know she has 2 kids now. They're like grown. I think they're like in college now. But like, oh my god, she's so disgusting. Was he Samoan? I don't know if it was Samoan. In the movie, he was portrayed as like, I think half Korean, half like, he was like a mixed kid. But he does look Samoan actually. Oh man, I was working at the gym, and it was getting my blood boiling. It was so bad. Let me see if I can find the interview. Let me see if I can find the interview. It's so bad, guys. What day was this? Oh, this right here. Okay. I don't know if you can watch it on YouTube because I might get hit with the thing. Oh man. That's why I love streaming on Twitch, okay? On Twitch, you deal with it afterwards. YouTube is so annoying. Hi, guys. We're here on Twitch. Hello, it's just us. So usually when I watch this, I try to pause through it a lot and talk through it a lot. But I let it run a little bit too long towards the end. And the YouTube, they detected that we were watching someone else's content. But I just had to show you guys bits and pieces of this, okay? Because it is so crazy. Like, this woman is wild. Like, please, if y'all know anyone who's like this in your life, y'all need to cut them out. Cut them out. Don't let them control you, okay? Don't let them control you. Don't let them have this power over you. Live your life, man. I feel so bad for him. But I hope he's living a good life now. And, you know, he's got many years ahead of him. But damn, like, this dynamic, this relationship is just so... It's just so cringe. Yeah, it's horrible. I feel like she could have been very abusive. Yeah, she doesn't understand that there are different levels of abuse. It's not just like physical abuse. There's a lot of emotional abuse that can go behind it as well. And clearly, like, he's always known her as the teacher. Like, he met her when he was 8 years old, okay? She was like his teacher when he was 12. Like, the dynamic is already so imbalanced. And even though he was 18 at some point and she got out of jail and they got together, but like, still... Like, how you see it right now, it's still like parent, teacher. Like, I don't know. It's just, ugh. Oh, man. But, you know, if you were on Twitch, the stream didn't go down. Hello. Hi. Yeah, we're back. Okay. Yeah, I don't know. I just wanted to show that to you guys because I watched it a couple days ago and it was bothering the heck out of me. It was bothering the heck out of me. Mary has come back to haunt anyone who has besmirched her name. Besmirched. I think besmirch is spelled... Actually, do I even know how to spell besmirch? Is it like that, maybe? We don't have spell check in the YouTube chat. Oh, Jesus. Like... Woody Allen. That one is a very interesting one as well. Yeah, because they're still together. Yeah, that one's a very strange one. I listened to her interview though. The woman that is Woody Allen's wife, but at some point he was dating her mom. That one's kind of an interesting one, but yeah, I don't know. Oh my God, she's like the one from Kitchen Nightmare. Which one? Amy's Baking Cafe. What is it called? Which one are you talking about? Oh, also creepy. Yeah, she's very creepy. Oh gosh. How's it going, Jan? Amy's pretty horrible too. I I think she still has like a bakery, doesn't she? I don't know what besmirched mean. I don't know when you like talk about someone in like a negative way. But yeah, oh my Lord. So today we covered Murdaugh stuff, a little bit about Sarah Boone. I think Sarah Boone's trial will be pushed. I don't think it's going to happen at the end of this month unless the judge is like, nah, we are going to have this trial no matter what. But the state agrees with it. The defense wants it. So I think Sarah Boone's trial will be pushed. I'll try to keep you guys updated with that. But earlier today, we watched the Alex Murdaugh hearing. It's a status hearing. The evidentiary hearing is going to happen in 2 weeks. And you might be wondering, evidentiary hearing? Why are we having an evidentiary hearing for Alex Murdaugh? Isn't his case done? Isn't the trial over? Yes, technically, he was convicted. He was found guilty for the murders of his wife and his youngest son. However, there were some allegations thrown at a court staff member that she may have said things to the members of the jury. And, when coming down with a guilty verdict, they can't have outside influence. It has to be from the evidence that they saw, from the testimonies they heard, circumstantial evidence or direct evidence in order to make their decision. No outside influence. So they are having an evidentiary hearing to determine whether or not the conviction is solid and sound. That's what we're doing with the Alex Murdaugh stuff. I don't know if I want to recap the trial stuff, the hearing stuff. Do you guys want to recap the hearing stuff or what the judge ruled? So on Alex Murdaugh's team, they want to pretty much have a pretty broad investigation, a very expansive one, where it's going to include Judge Newman to be questioned, Creighton Waters, the state attorney, his paralegal, Becky Hill's daughter, alternate jurors. Like they wanted to include a bunch of people into the questioning, and they said they had thousands of emails that they're going to use against Becky Hill. But the judge was like, no. We're not going to do any of that. We're just going to start with the jurors. And we'll, of course, question Becky Hill because she's at the center of these allegations. So that's why Harpoot Leanne and the judge were going back and forth a little bit. And the judge kept repeating herself, saying that like, oh, no, I made my ruling for now. Like, we'll explore it when it comes. But right now, we're just going to focus on the jurors and Becky Hill. And we're not going to explore other allegations about Becky Hill. We're just going to focus on what she said, if she said anything, and whether or not that influenced the jurors. So I like that. I think it's a good start. Start very specific, and then we'll work our way out depending on what comes out of the questioning of the jurors and Becky Hill. So yeah, that's where we're at with Alex Murdaugh. That's going to be in about 2 weeks. I'll see you guys. It's going to be 3 days, and I don't think, do you guys, here's the thing. Do you guys want me to start on time? Like when the hearing actually happens? So like when we have trials, when we have hearings, do you guys want me to start on time, or is it okay? Cause like what I usually do is I'll start like maybe like 2 hours behind, and then we kind of just catch up because they have breaks, lunch breaks and all that stuff. I don't know. Cause I feel like there are a lot of people that don't wake up super early, right? Of course, there are people who are from the East Coast. There are people who's from the Mid Coast. Sorry, I always say Mid Coast. I think it's funny. But for people who are on like, we're on the Pacific time zone or like Hawaiian time zone, like it's super early for us. But would you guys rather have me start on time? Is it better? Or I don't know. Is it okay that we just play catch up? I don't know what people prefer. I feel like people probably prefer me to start when the trial or the hearing actually starts. But Sarah Boone's trial been pushed back to May, apparently. Yeah, because I didn't think it was going to happen in January. I mean, I was hopeful that it was going to happen in January because let's just get it over with. But her attorney just got on board like a couple months ago. And there's a lot of things that he needs to do. And he's a public defender. He's probably juggling other cases as well. But where did you hear that to go? Because I'm trying to see if we'd have the status hearing on YouTube. I don't think I found the status hearing. Let me check on YouTube again. Sarah Boone status hearing. I don't see anything. Sarah Boone. I can go in her docket again. Sarah Boone. Oh, is it on Court TV? Is it on Court TV YouTube or Court TV? Because I checked Court TV earlier and I didn't see that. Oh, 2 hours ago. Okay, this is new. Oh, sweet. It is on Court TV. What? I tried searching it on Court TV. It didn't pop up. Did they just upload the video on their YouTube channel? Or did they only upload it? Oh, they might have just uploaded on their website. shall we watch? Here we got Sarah Boone. Where's the audio?
CF 2603, state.
Dave Cacciatore on behalf of the state.
Cacciatore.
Mr. Cacciatore, good morning. The court was just made aware that a motion to continue waiver of presence was filed on January 12th, 2024 at 11:18 a.m. A copy of it was not favored to my office. My judicial assistant found it this morning by scouring the record once we did a call in the halls for counsel for Ms. Boone. The motion reflects that additional time is needed in order to prepare this case for trial. Counsel is still reviewing extensive discovery in this case and is also seeking appointment of experts with the S in parentheses. This court has approved costs for a private investigator. The task to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. Reflects that speedy's been waived and that you had no objection to same. Is that accurate with regard to your objection or lack thereof?
That is, and I've had the chance to review that motion, Your Honor.
I'm sorry, Mr. Cacciatore, say again, sir?
That is accurate, and I have reviewed defense's motion to continue.
Okay. The motion does not identify the amount of time that they're seeking a continuance. In your conversation with Counsel Hobson, are you in a position to advise the court as to how long of a continuance they're seeking? Oh, no, the wherefore clause says 3 dockets. I apologize. Any objection to that, sir?
No, Your Honor.
Dr. Pepper is disgusting, by the way.
Okay. The motion to continue will be granted. This matter will be continued for 3 dockets. Now, my understanding is that this is typically specially set. So do we want to have this especially set at a certain time, Mr. Cacciatore?
I think that would probably be better. Typically, Ms. Boone is elected to attend many of these hearings and not waive her appearance at them. So I also think too that we're at the point that we're close to being I think ready for trial, and that I guess without getting into too much more without Mr. Hobson here, yes, I think just we could set it for a special set status.
Yeah, I feel bad for the family members of the victim because, like, I know you probably just want to get this over with. Like, having to anticipate, like, the trial, okay, it's going to happen in 2 weeks. Oh, wait, never mind. It's not going to happen in 2 weeks. There's going to be a continuance. I know you got to clear your schedule. And, like, I don't know. That's very stressful for the families of the victims. Right? Coca-Cola, let's go. I don't like soda, period. Yeah, that's probably good. I have an addiction to soda, to all that kind of stuff. So I try not to drink it as much. But once in a while though, Coca-Cola with a straw and ice. Oh, so good. So refreshing.
All right, the court has availability for a special set on May the 3rd at 9 a.m. The court's inclined to have this as a special or as a final continuance due to the age of the case and the motion not specifying anything more than a 3 docket continuance.
That's acceptable.
Okay, all right, we'll set this matter for a special pretrial on May the 3rd at 9 a.m. Ms. Boone we'll have a mandatory appearance for Ms. Boone at the May 3rd at 9 a.m. pretrial. What's the following trial period for that?
The trial period for May the 3rd would be May 13th.
All right, with a trial period of May the 13th.
Jesus.
Thank you, Your Honor.
All right, thank you, sir.
Well, that's Sarah Boone. Jeez, I didn't want them to push it that far out. Like, I didn't want to have Boone and Murdaugh's evidentiary hearing happen at the same time, but May, that is so far. Oh my God. May. All right, let's look at our schedule together. Let's what do we got for our schedule? You guys want to see my notes? My notes? Can you see my notes? Oh my God, what is this liver thing? Oh, you probably can't see my notes. Oh, whatever. You don't need to see my notes then. All right, so what we got? We got Boone, cancel. Delete. We have Murdaugh's evidentiary hearing. It's going to be 3 days long, from 29:30 to 31. Monday, Tuesday, Wednesday. That's going to be January, end of this month. February 6th. Oh, Adam Montgomery. Oh my God, that kid is so sad. I don't know. I have Adam Montgomery for February 6th. I don't know if that's going to still be a thing. I haven't really caught up. I haven't been up to date with that one. We have February 20th, 10 a.m. sentencing of Ruby Franke, and then 10:30 a.m. sentencing of Hildebrandt. March 12, Karen retrial. I kind of want to do research on the Karen retrial because this case sounds wild. Wild. It is far away, but the judge said this would be a final continuance. I don't know if he said it was going to be a final continuance, but he said that I think they're trying to, like, pushing it 3 dockets away is like the minimum probably, because they need to get this case like tried like ASAP, because it's been pushed so many times. But I don't think like if something happens, right? They might have to push it out even further or even more. But yeah, I don't know if you can just like set like, okay, this is the last time we're doing continuance ever, no matter what. Like, I think sometimes things just happen, right? But I don't know, it's up to the discretion of the judge. He can just deny it in the future if they want another continuance. All right, so we have Karen Reed trial, which I don't know if you guys have been following the Karen Reed one, but that one seems crazy. Chad Daybell is supposed to have his trial on April 1st. I highly doubt that. His lawyer has called it quits. Chad Daybell cannot afford his attorney, so I don't think his murder trial is going to happen April 1st, because also, you guys have to remember, it's also a death trial as well. It's not just like him going to jail. He might get the death penalty. May 2024, we have Petito Schmidt and the Laundrie civil trial. From what I've heard, I think a couple months ago, the Laundries, they tried to settle, and the Petito Schmidts were like, nope. And then in May, we have Sarah Boone stuff. And then going towards summertime, it's just Dorman, disgusting dad who shot his 3 sons. Maybe Larry Millett. I don't know. Millett. I don't know how to pronounce that. And then Alexi Treviso is like maybe like fall season. I don't know. That's what we have so far. Yeah, I don't really know what's going on with the Koberger stuff. I don't think we have a set date for the Koberger stuff. Because initially he didn't waive his right to a speedy trial, and they were gonna have it like within like well, actually, oh man, that shit got like super pushed. The trial was supposed to happen like within a year, right? Wait, did he waive his right to a speedy trial? I think initially he didn't, but things kept getting pushed. Things kept getting pushed. But yeah, I don't know really what's going on with the Koberger stuff. Cameras, I think they're going to allow that in. Fighting over the DNA stuff. I don't know. I've not been caught up with that. Right? The Karen Reed stuff is pretty crazy. I'm like, do I have time to do a whole video on the Karen Reed stuff? Wild. The Richard Allen, I have not been following the Richard Allen, the Delphi case, right? Yeah, I haven't really been following that. Following it loosely. I watched a true crime video on it a couple years ago, but I don't know. A lot of stuff in the pipeline. A lot of stuff happening. Jesus. All right, y'all. Well, I mean, that is it for today. We covered Mary Kay Letourneau. I don't know how to pronounce her last name. Disgusting woman. We hate her. But yeah, I hope things are going to be better for Billy. I wish the best for Billy. Poor guy. We covered the Murdaugh stuff and Sarah Boone stuff. And that's about it. Oh yeah, I saw that they demolished the house, the Koberger, where the killings happened. Yeah. There are line cameras in Delphi case. Courtney Clenny. Oh, I for sure will watch that trial when that happens. I will for sure watch that. Courtney Clenny, we watched the video that was released recently of her just like beating up her boyfriend at the time. Things don't look good for her. Leela, thank you. Oh my gosh. Leela, thank you so much for the 5. Oh, thank you for the support. I appreciate it. Thank you. Thank you. I appreciate the super chat. Thank you, Leela. Yeah, we are going to for sure watch the Courtney Clenny trial whenever that happens. But for this week, I'm probably going to stream again one more time, and we're going to finish up. Oh, I'm sorry, y'all. I could not sync the audio for the Wendy Adelson interrogation. That's already out on my YouTube channel. I wanted to sync it, but I didn't realize that the sync was off it depends on like what part of the video you're watching, but it could be off by 2 seconds, 30 seconds, 1 minute. Like it was just all over the place. So if I were to sync it, it would have been really, really, really hard. Yeah, it was really tough. And also the camera's like super blurry, so I couldn't really see Wendy Adelson's like lip motion. So to like, even if I wanted to sync the audio and the video, it would have been really hard to do that. But yeah, I'm sorry guys, I couldn't sync that. I tried. I kept saying, I'm gonna sync it. We're gonna do this, but I couldn't sync it. So we're gonna finish up with Wendy Adelson's interrogation, and then I want to watch Charlie Adelson on the stand. And yeah, we have a lot of like Adelson stuff that I just want to catch up on. But oh wait, does anyone know Donna Adelson was supposed to have a status hearing, but they canceled because of they were having like weather issues, right? What's going on with Donna Adelson? Donna Adelson. When is her next court appearance? Does anyone know? She had a status hearing, but that was canceled. So when did they reschedule that? Does anyone know about that? I know so I bought this bed for him because we actually have a bed in our bedroom, the same one, the pita bed. But I was like, I think he gets cold. I think he just wants something cozy to sleep in. So I bought this and he wouldn't use it for like a month or two. He wouldn't use it. So I finally got him to use it. And now he just looks so cute and cozy. Izetto side. I don't know who that is. Who's Chris Chan? I don't know who that is. Are you guys watching any TV shows right now? Anything good? Anything good going on? Any movies? Wendy, don't worry. The videos were like, it was like, did they record this with like, is this like VHS? Because it was so blurry. The date timestamp was like huge. Oh man. But I mean, I still want to watch it, but I don't know what's going on with Donna. Anything going on with Donna? All right, let me go on my YouTube to see if there's anything else we can chat about, but I think that's about it. Louder Milk. Oh, what is Louder Milk about? I haven't heard about that before. I want to watch, you guys told me about this super evil, crazy TV show with Glenn Close. Is that her name? It's like super evil. I think it's on Hulu. I wanted to start watching that. Modern Truman Show. Really? Oh, I've never heard of that person before. I don't think. Have I? No, I don't think so. Oh, yes. Damages. Yeah. I wanted to start watching Damages. You guys made it sound super crazy. So I want to check it out. Watching Marry My Husband. Okay drama. Yeah, there's some good K-drama that I added to my list. They're all like dark ones. But if you guys have any like recommendations on like romance stuff, like I am down. Oh, you know what I'm watching right now? This is like a trash, like teenage, like 50 Shades of Grey stuff, but I sort of enjoy it. No, I do. I enjoy it. Ever After or Happily Ever After, or what's it called? After? It's like a series. It's kind of like 50 Shades of Grey, but it's targeted towards like younger people. That just came out. I started watching that. Really? Deep Dive True Crime has a full... What? Really? How did they sync it? I tried. Maybe I just gave up too easily. Interrogation. Let me see if I can find it. Can you link it? Oh, is this it? Oh my God, is it synced? Deep Dive True Crime.
In Fort Lauderdale.
Okay. All right. So that's where you're.
But I wonder, he's very, very.
Yes, it's synced. Oh. Guys, Deep Dive True Crime. We've been watching a lot of the stuff that they've been posting about the Markel stuff, and Adelson stuff as well. Oh, it's synced. Thank you. Thank you so much. Oh, thank you. Huge thumbs up. All right, everyone go to this video, give it a thumbs up. We can finish the interrogation. Yay! And it'll be synced. Yay! Okay, thank you. I appreciate it. All right, y'all. I am going to go take a shower. I'm going to wash my hair, eat some lunch, and yeah, take my doggy out for a little walk. I'm going to take Shiro outside. Hey, Shiro. Look at him. He's so cute. Look, Shiro. Hey, Shiro. Hi, Shiro. Yeah? Want to wake up? Are you comfy? You look so comfortable in there, Shiro. You look so comfy. All right, y'all. If you haven't already, join the Discord. If you haven't already, get the Discord here. The X-Files. I've always wanted to get into the X-Files. The Office, Fringe, Battlestar, Galactica. You guys probably have some like good show recommendations. I wanted to watch X-Files, but I feel like X-Files is just so creepy. I don't know. X-Files seems so creepy. But I know they remade X-Files, didn't they? Do you watch the new version of X-Files or the old version of X-Files? Yeah, I like the female actress who's in 50 Shades of Grey. She always has like is it Dakota Johnson? She always has like the same hairstyle no matter what she's in. I like her in movies too, and I like the way she talks. Oh, you finished 1899? How was it? Dude, 1899. If you guys like Dark, I think it's a German TV show. If y'all like Dark, watch 1899. Oh my god, it's so good. I enjoy it. But anyways, y'all, thank you so much for hanging out with me today. Thanks for keeping me busy. Thank you for your support. Thanks for having me in the background while you're multitasking over there. And yeah, guys, join the Discord if you haven't already. Those are all my social medias. Like the stream, comment the stream. I don't know. Subscribe to stream. I hope you guys have a good one. Is there another season? There should be another season that comes out. Yeah, for sure. There's no way. That was like a cliffhanger. There has to be another season coming out. All right, y'all. I hope you guys have a good one. And is it even worth me putting my makeup on today? Because I have to film stuff. Yeah, I guess I'll try. All right, y'all. I hope you guys have a good one. Take care. And I will see you guys later. Thanks for joining us.